Assalamualaikum and good day everyone. Welcome back to Iuris Scientia for the Soul episode 7. For this episode, I will be a presenter. My name is Alyaa and our topic for today is the legal doctrine of estoppel. Estoppel is recognized both at common law and rule of equity. The term of estoppel is derived from the French word estoppel that gives the meaning of stopper, bang. This doctrine of estoppel is used in certain situations to prevent a person from relying upon a certain right or upon a set of facts which is different from an early set of facts. In a simple word, estoppel is principle of justice and equity. It comes to this: when a man by his word or conduct led another to believe in a particular state of affair, he will not be allowed to go back or take back his word, as it will be unjust and inequitable for him to do so. There are two types of estoppel: estoppel by representations and equitable estoppel, which consists of promissory estoppel and preparatory estoppel. For today's episode, I will discuss about equitable estoppel. Equitable estoppel consists of two estoppel: promissory estoppel and preparatory estoppel. Promissory estoppel is when a person is precluded from retract from his representations or promise. Has four elements that need to be proved before plead for a promissory estoppel. The first one is there must be an ambiguous statement or a clear statement of promise or assurance made by the promiser. Next, the second element is the promiser is intended to effect the legal relation between the party. The third element is the promisee must act upon the promise, and lastly, by acting upon the promise, it alters the positions of the promisee to his detriment. However, must be noted that promissory estoppel must intended to effect a pre-existing legal relationship and only can be used as a defense to an action brought by a promiser. A good example of promissory estoppel can be seen in the case of Central London Property Trust vs. Hightree House. In this case, the defendant leased a block of flat from the plaintiff. The property suffered from falling occupancy rate due to the outbreak of the World War in 1940. So the parties agreed to reduce the rent by half. However, it was not expressly agreed how long this would last for. So the defendant continued to pay the rent at this new rate. By 1945, the war has ended and the flats were at fully occupancy. The plaintiff sued defendant for the full rent from 1945 onwards. The court is in favor with the plaintiff because if the plaintiff claimed during the war, then the plaintiff will be estopped. However, since the claim was made after the war, then the court allowed it. Let's move on to the preparatory estoppel. Preparatory estoppel is a type of estoppel operated in respect of right to occupy the land or buildings. Like promissory estoppel, there are also four elements that need to be established before plead for preparatory estoppel. The first one is there must be some encouragements made by the landlord affecting the claimant belief. Next, the claimant must have act in the belief that they either own or will obtain a sufficient interest in the property to justify the expenditure. The third element is the claimant must have incurred expenditure or otherwise aid to his detriment. And lastly, there must be no bar to the equity such as the contraventions of any statute. The case of Inward vs. Bakers 1965 is the perfect example of the preparatory estoppel. In this case, a father encouraged his sons to build a house in his lands. The son built it at his own expense using mainly his own labor. The house was complete and the son moved in and remained there. So when the father died and left his property to his partner, Mrs. Inward, she brought an action to remove Mr. Baker from the property. So the court held that Mr. Baker was entitled to remain in the property. His expenditure of money on the land at his father's encouragement raised an equity which satisfies, and Mrs. Inward was estopped to remove Mr. Baker from the property. To conclude, we can see that the difference between promissory estoppel and preparatory estoppels are the promissory estoppel may be permanent, but preparatory estoppel is permanent, and promissory estoppel merely provide as a defense, whereas preparatory estoppel provide cause of action.